English shorthand dictation number 304, and the dictation speed is 100 words per minute. Ready? Start. I feel a sense of pride and privilege in being given an opportunity to preside over this historic High Court, which is one of the three chartered High Courts and has completed 150 years of its existence, along with Calcutta and Bombay High Courts. The Madras High Court is a trailblazer with several firsts. This court has seen a grand mix of European and Indian lawyers rubbing shoulder to shoulder. Great lawyers have shown their eminence in the national capital and who are veritable role models for a whole community of lawyers across India. Each one of them has left an admirable chain of talented juniors. This court has also produced outstanding judges. You can be proud of the fact that Mr. R. Venkataraman, former President of India, is also from your bar. The litigation emanating from the Madras High Court and going right up to the Supreme Court has given a new dimension to the Indian Constitution. The movement of social reformers and great stalwarts outside court in public life found matching judicial pronouncements that shaped constitutional jurisprudence in several areas like human rights, land reforms, public law remedy for securing compensation against violence and loss of property, etc. My endeavor to refer to this past glory is with a certain objective, the immense responsibility on all of us to carry forward the tradition of greatness. We will only deserve such place in history as the collective efforts of lawyers and judges bring to the cause of justice and service to public. The noble profession carries with it great sense of responsibility. The public looks towards us to provide them the elusive justice, and lawyers and judges are an instrument to do so. Like a temple cannot remain closed, a temple of justice can also not remain closed for the teeming millions of this country. It is no answer to them to say that courts are not functioning for one reason or the other, and that we failed to provide the service in a manner befitting the profession we carry on and the office we hold. Lawyers and judges have to take a step forward towards the vision of better work culture, organizing a transparent system where the litigant does not find access to justice as a burdensome adventure. In this age of technology, we cannot expect the public to wait indefinitely for us to find an ideal solution. There has to be prompt justice. Thus, there has to be a two pronged strategy. First, pendency of old cases must get some priority as litigant has waited enough, and one must make sure that the current institution does not result in a similar long pendency. This is easier said than done, but nothing is impossible if we make a joint effort. Secondly, use of optimal computer technology for all round improvement in justice delivery system coupled with better court management can go a long way to get a better output. At the same time, conventions must hold good, but then change is also a necessity as we cannot be stuck in a time warp. Each case should be able to be tracked from its cradle to grave, starting the time when a case is instituted and right through different tiers of scrutiny. Efforts have to be made to see to an early disposal. We have to use technology to deal with high volume of pendency. Let me say that I am not deterred by the large institution of cases. It should be taken as a reflection of faith of the people in the system, but the pendency of cases acquires the character of areas not on the date of the institution, but when they cross the ideal time fixed for their disposal, keeping in mind the nature of the case. The Madras High Court has been an example for the experiment of mediation process. It is from there that the then Chief Justice of Delhi, who was also the Chief Justice here, got mediation to Delhi when I was the judge of that court. We have had the benefit of guidance from the expert mediator of this court. I see no reason as to why we cannot utilize a vibrant alternative dispute resolution mechanism to reduce the burden of the court and also to provide more palatable solutions. In certain areas of court administration, private enterprises may be useful. This can be in developing system of court management and translation of publication of important judgments of this court in Tamil language, which is the language of the people. Tamil language has given to the world great concepts. Even the symbol of balance to justice must have been an inspiration from Tamil epic Tirukkural. I have had the opportunity of interaction with eminent lawyers from here while practicing at Delhi and also found them appearing before the bench on account of their prominent presence in the Honorable Supreme Court. On my recent visit in April to Madurai and then driving to various historical monuments, I was greatly impressed by the cleanliness and neatness maintained. Education is being used as a tool of improving skills. The people of the state thus have the commitment to the larger cause in which discipline plays an important role. On this occasion, I would make a humble request that everyone must abjure lawlessness in court complexes, cooperate with each other, and continue to provide justice to the common man uninterrupted. The court must be demystified for the litigant by making information available through technology or otherwise so that they have an easy and simple way to access justice. I am thankful for the kind words spoken about me by the Advocate General and others. I will do my utmost in living up to your expectations, and I need the cooperation of all of you. I am of the firm view that success of the legal system depends on the cooperation between the bench and the bar. You have raised certain demands, and I assure you that I will discuss with my brother and sister judges and will see to it that they are met as far as practicable.